motion to revoke, it is relevant to look at his performance while on probation, particularly when he is requesting to stay on it.
I think coming at it aggressively might not be the way to do it, and that's what I just said. You seem very frustrated, and I'm not sure why.
I'm confused why there's pushback at all on any request for a 3914 discovery when he's constitutionally allowed to access this file.
Well,
that is alarming to me that we would have to even compel anything under 3914.
Hold on.
Yes,
and the last thing you want to do is talk over me.
Pause right here, because this is where courtroom etiquette matters more than legal arguments. Talking over a judge isn't just rude, it's procedural suicide. Judges control the room, the pace, and ultimately the outcome. Once a lawyer crosses that line, every valid point they had instantly loses power. Question for you. Do you think this attorney is strategically pushing boundaries or emotionally losing control already?
All right, this is cause number 1830854, and sir, you're Juan Sanchez?
Yes.
And so we're here today on a motion to compel, and before we get into a whole lot, I've done a lot of my own research and looking at all of this, and a couple of things. One, I don't believe the subpoena ducis tecum was the proper way to try to get the information. Ducis tecum is an order to get somebody to bring something to a set hearing. So, but we didn't have a set hearing, and they weren't ordered to give it to at a set time for a hearing. So, under the rules that have to do with subpoena ducis tecum, I don't know that that was the proper way. I do think you're entitled to some of that information as a defense attorney. If we're going to base decisions on, if I'm going to base decisions on things that probation have in their file and that they're just going to tell us, I do believe that you are entitled to some of that information. I think the proper way to do it would be to make that request through the district attorney's office for discovery. And then for you, Mr. Nichols, to make those requests, and then I would approve you guys giving whatever records are requested within reason. If you have, I don't know what would necessarily be any type of work product that would not be discoverable, but if you think that there's something that is particularly not discoverable, let Mr. Nichols know that, Mr. Nichols let me know that, then we could worry about maybe a motion to compel and whether or not I think those things are or are not. But lab results, testing, money owed, all of those types of things, I think are probably discoverable and something that Mr. Franklin needs. I just don't think this was the...
I agree, Judge. Any of the things that pertain to, well, I do think it's discoverable. In this case, it's all allegations on the motion are based on arrest out of county. And so his attendance record and all that, I don't know why we're subpoenaing the entire probation file when it's not even part of the allegations for the motion.
May I respond, Your Honor?
Well, let him finish, yes.
He did subpoena Wharton County records, so a representative from probation down there came in today for this hearing. I have no problem with getting him all that stuff. A lot of it's not in my possession. The out-of-county offense reports and things like that, I don't have yet. I would have them if we move towards a hearing where I prove up those allegations, and they, of course, will be provided beforehand. And again, I don't think he's not entitled to have all that stuff. So
sure.
I kind of agree with I don't want to subpoena directly to those agencies was the proper way to do this. And Mr. Franklin did make just a standard discovery request at the onset of his involvement, which was early May. I don't have anything really responsive to that at this point.
Okay. So obviously, if it's based on a new offense out of another county, that's something you'll need to work towards getting and get that to Mr. Franklin. And so that needs to take place as quickly as possible. Let me look at the motion itself. Because I don't know, I guess, Mr. Franklin, if there's not an allegation in the motion to revoke with regard to certain administrative violations and there isn't an allegation, then why would you, what is your argument that that would be relevant or discoverable?
Your Honor, my client is wanting to stay on probation, and the court may take into consideration his performance while on probation, including his payments, his report, and everything else. So as part of determining the motion to revoke, it is relevant to look at his performance while on probation, particularly when he is requesting to stay on it. And he's been on probation nearly 6 years, I think over 5.5 years, nearly 6 years. And that performance will be helpful in determining or mitigating whether he stays on probation or if the court decides that he goes off of probation, and perhaps mitigating any potential sentence.
Okay,
And
I don't disagree. So, again, though, I think the way to do it would be to make that request. I mean, and I don't know what conversations y'all have had, but make the request. I think coming at it aggressively might not be the way to do it.
This is actually a crucial legal moment. The judge is agreeing, yes, the defense is entitled to discovery, but she's also saying you used the wrong tool. A subpoena ducis tecum isn't a shortcut. It's a formal mechanism with strict rules. The irony? If the attorney had slowed down and followed procedure, he likely would have gotten everything he wanted without resistance. So ask yourself, is aggression helping or actively hurting the client right now?
Sometimes you get more with honey than otherwise, so make the request to Mr. Nichols. If he says no, then let's go through what we need to go through. But let's try to do this amenably. The ducis tecum is not the way to do it unless it's set for a hearing. That's just the rules of evidence, and
Yes, Your
so
Honor.
that's not the way we're going to do
The
it.
ducis tecum was set for the day that it was initially set for a hearing, and it did specify that date for the hearing, I believe. And we ended up moving the hearing date because of conflict.
And Judge, I'd ask Ms. LeBeau to go ahead and get everything together today
Yeah.
to turn over.
I mean,
Unless
yeah,
there was something that the court was ordering her not to turn over.
I don't think on this list that there are, I mean, is there anything that y'all specifically had an issue with?
Ms. LeBeau, or do you have any concerns you want to
If there's,
make the court aware of?
Your Honor, just with the clarification of our departmental chronologicals, which include anything that pertains to the case that happens, we chrono telephone calls, auto-generated appointments, reminders, office visits, drug tests, anything that we enter into the system. But those are the chronologicals through the probation office, as well as releasing of the jail logs, his sex offender verification, interlock reports, because those were not listed on the subpoena, as well as the offense report through DPS, which was released to me and my under a supervision officer. So just to clarify as to those items specifically being released that were not listed with the exception of the offense report.
Your Honor, we don't have to list those. We filed a 3914 discovery request. This was belt and suspenders because we didn't get any of the information relating to probation in our 3914 motion originally. I would also note that the chronologicals.
well, and these aren't, the reason you didn't get any of those is because those aren't his, they're theirs. And so they're not, I don't think Mr. Nichols has the ability legally to make probation give them those. I think once we talk it out, though, I think whatever Mr. Nichols, y'all get together, obviously offense report, if y'all have the offense report and you don't even have it, then you need to get, I mean,
Right, I mean,
that's great.
it's
Everybody
all
can
stuff-
get the information in an amenable way. So let's do that. Y'all sit down. I want everything that you have that is, I don't know that there's anything I can think of that would be,
Unless, I mean, I guess
Not-
notes may be work product, but I'm not real,
that's what I'm thinking about, but it's
Not
not
too
really
concerned.
attorney's notes, and so I don't know that that would
I
be an
would object to
issue.
that, Your Honor, on the grounds it's not attorney work product. It is merely work product of an employee, and it is discoverable and relevant to the case.
And that's what I just said. You seem very frustrated, and I'm not sure why. I don't know,
I'm confused by if there's pushback at all on any request for a 3914 discovery when he's constitutionally allowed to access those files. It should just be produced by probation without a fight. And we got a letter anticipatorily repudiating any production of discovery, and we had to file a motion to compel to that effect.
Well,
And that is alarming to me that we would have to even compel anything under 3914.
this is not something that a lot of attorneys have done in our cases. And so if there is something, if you'll sit around and watch today how everybody gets along, hold on.
Yes,
And the
Your Honor.
last thing you want to do is talk over me.
Yes, Your Honor.
So I'm standing here, or sitting here saying that I agree with you, and you're still being argumentative, even towards me. And that's not going to get you anywhere. Hold on. Being argumentative with Mr. Nichols isn't going to help Mr. Sanchez. Being argumentative with these ladies isn't going to get you anywhere. I agree that you're entitled to this information. I just think there's a better, less argumentative.
This is the breaking point. The judge is no longer debating law, she's correcting behavior. When a judge says, I agree with you, and you're still arguing, you've officially lost the room. From here on out, this hearing becomes about tone, not facts. Final question for you. If you were the defendant sitting next to this lawyer, would you feel protected or panicked? Subscribe now and comment below. Was the judge's decision fair?